All right, moving right along now. We're still on intentional torts, but we're on section B, which is defenses to claims for physical harms. Physical harms being the things we discussed last time, like battery, assault, false imprisonment, things of that nature, or even trespass to chattels, conversion, anything that was basically an intentional tort. These are the defenses that might be used by a defendant to get out of liability. The first of two is consent. The idea here is that the defendant will say, "Well, yes, I suppose I did do those things, Your Honor, but I had permission to do so." So, battery, for instance, as you recall, is a harmful or offensive contact with plaintiff or anything connected to the plaintiff. Imagine that the defendant punched the plaintiff in the nose, all right? A punch is a harmful contact, and the nose is clearly part of the plaintiff, or if he has a nose job, it's something that's now attached to the plaintiff or held by the plaintiff. But what if there are two boxers? There's consent. You're not liable in that instance. Of course, that's a real clear cut uh, example. Things get a little bit more complicated. Imagine a scenario where I decide to let somebody borrow my car for the weekend, and Monday comes around and there's no sight of my car. At that point in time, they have committed a trespass to chattels. They are violating my possessory interest because that's my car and I don't have it because this person took it from me, essentially. Uh, but to get back to what consent is, it's an affirmative defense. That means the defendant bears the burdens of evidence and persuasion. The plaintiff, when he brings his case to court or makes files a complaint, he doesn't have to mention the issue of consent. It's up to the defendant to advance that as a defense, if indeed it's relevant. And at that point in time, the plaintiff can argue against that, saying, "Oh no, you did not have consent for X, Y, or Z reasons." When you're writing a essay response on the exam, on the bar exam, and an issue like this comes up, oftentimes you might have one section where you explain why the defendant was or was not what did or did not satisfy all the elements of a tort, and then in the next section whether or not there was consent or other or privileges or immunities, which we'll get to in a second. An important issue here is the scope of consent. I just brought up an example of where I allowed somebody to drive my car for the weekend. Monday comes and my car's not there. The scope of that consent was the weekend. And if when Monday comes, the scope is now over and there is a possibility of a tort. So the bar exam alert here is to make sure to identify the scope of consent and determine whether the defendant stayed within that scope or if he exceeded it. A couple other issues regarding consent. The first is capacity to consent. There must be what's called legal consent. The person giving the consent has to be of an age where not an infant, like it was what they call it. I don't know why they call it infant. An infant's a baby, but legally speaking, an infant is somebody that's below 18 years old. So a 12-year-old can't be playing with, his bicycle, his BMX. Some adult shows up and says, "Oh, can I take that for a couple months?" And the kid says, "Sure." No, he doesn't have capacity to make that type of consent. You have to talk to his parents. And another example would be some sort of mental infirmity where somebody is mentally unfit to make decisions for him or herself. The second issue is whether or not the person giving consent had authority. Obviously, the plaintiff himself has authority to give consent over issues relating to his property and himself. But the more complicated is when we're talking about actual or apparent agency. In other words, if there is an agent involved. If I'm out of town and my buddy comes by and my wife tells him, you can borrow my husband's guitar. He told me that you can borrow it for the weekend. Now, there are a couple issues here. First of all, whether or not the wife is an agent. If I tell her to tell my buddy something, she becomes my agent. I gave her authority to do so. So that person can bring up a consent defense if later on I try to sue him for conversion or trespass to chattels. Secondly, let's say for a second that I did not give my wife authority. I just left town, and for whatever reason, God love her, she decided to tell my buddy that he can borrow my guitar. Was there apparent agency? Was my buddy justified in believing that my wife was my agent? That's the question. In that instance, that does seem pretty justifiable, especially if in the past she had given that type of done that type of thing on my behalf when I've been out of town, telling friends, yes, you can borrow the guitar. It comes up in instances when a company, let's say, I don't know, the New York Giants, if the owner of the team told me that I'm allowed to go into the MetLife Stadium on a certain day and play football there, let's say, right? Okay, he's clearly has actual agency, or he owns the team, he controls the facility. But what if the water boy came up to me and said, "Oh, you're allowed. Don't worry. I'll make sure it's fine. You can go to the field." If I show up, I'm going to be arrested for trespassing, and I'm going to be sued for trespass to land, because there is no way I was justified in believing that some water boy had agency for the New York Giants or for MetLife Stadium. In other words, there was no apparent agency. It was unreasonable to believe that person had authority to provide consent. Okay. We talked about capacity to consent, authority to consent, and now here's the evidence of consent. Now, you go to court, and the judge says, all right, fine, you said there was consent. Well, what is the evidence of consent? What happened? There are two types of consent. The first is express, the written or spoken. Your Honor, I have a letter here saying I was allowed to do this, or I was told that I was allowed to do this. Easy. Of course, it can't be the product of fraud or duress. This is common sense stuff. More complicated is implied evidence of consent. In that instance, it is what is reasonably inferred from social custom or non-verbal conduct. I ask somebody, can I take your car for the weekend? He nods. Or some sort of social custom. You're at a park, you're on a playground, you sort of consent that you might get bumped into by other people. Instead of being on a playground, if you are relaxing on the beach in a beach chair, you do not consent to be knocked into by somebody playing a game. So the consent here, it's interesting, because the battery is sort of any unwanted or illegal or improper touching. So if I'm minding my own business on the beach, like I just said, reading a book, and somebody bangs into me, they're playing a game of touch football on the beach. Listen, that is, I have a right to be peacefully sitting there on the beach. That's a battery against me. But if I'm in the ball pit at McDonald's and someone knocks into me, that's the sort of the risk you take when you enter the ball pit at McDonald's, among other risks when you are in the That ball pit at McDonald's would be pretty disgusting in my opinion. Although I do love McDonald's, not the ball pits. The second defense to claims for physical harms are privileges and immunities. This essentially gives the defendant an excuse. Your Honor, yes, I satisfy all the elements of this tort, and I didn't have permission to, but please excuse me because I had to. Here's an example of when there is no excuse, no privilege or immunity. Bill commits a battery if he decides to punch Steve because Steve is a fan of a rival sports team. He's a jerk. He committed a battery. There's no excuse for that, unless the guy is an Eagles fan, Cowboys fan, Redskins fan, or any of those teams, in my book anyway. But moving right along, an example of when there is an excuse, when there is privilege or immunity. Bill is permitted, I don't know why I put that in quotations, I'm sure some people would take issue with that because he is permitted. But I suppose it's because it's an excuse. We let you do it, but we wish you didn't have to. You're excused from it. All right, so I'll keep those quotations there. Bill's permitted to punch Steve if Steve is a burglar who broke into Bill's home and threatened his family. It's technically still a battery, since all the required elements are present. It's a punch to somebody's body. But Bill is immune from liability because he's privileged to throw a punch in this scenario. Yes, I would have to imagine that would be the case. It would be a sad state of affairs when people could just come into your home and threaten your family. The underlying conduct is the same, but the circumstances are different. Again, these are affirmative defenses, privileges and immunities. The defendant bears the burdens of evidence and persuasion. The plaintiff doesn't have to mention this at all. It's up to the defendant to say, Your Honor, there was a privilege or immunity, and at which point the plaintiff can counter that if he chooses to do so. So let's take a look at some of the privileges and immunities. This is common sense stuff, self-defense. I mean, obviously, you're allowed to use the force necessary under the circumstances to address a reasonable belief regarding a threat that is in progress or imminent. Now, there's a lot, when it comes to type use of force, like in Fourth Amendment criminal investigation, there is a lot of a body of law that regulates when and how and whatnot. But in terms of torts, we're talking common sense reasonableness. We're not trained police officers in using protocol. We're just people living in the world. Things happen, and you have to act reasonably. If I'm walking down the street and someone jumps up to me with nunchucks and goes to attack me, I need to act, and I am allowed to use force that's necessary under the circumstances. It's a sniff test, a reasonableness test, common sense. And here are some of the common sense things about it, or characteristics of it. The level of force has to be reasonable. You can't shoot somebody who threatens to tickle you. Duh. The belief about the threat has to be reasonable. You can't assume that someone's trying to kill you just because they look a little bit sketchy. Now, even if a threat turns out to be wrong, that's really of no consequence. All we're caring about here is the circumstances in the moment from the perspective of the person. And did they or did they not act reasonably based on those circumstances? A terrible example, I actually saw this in the newspaper, that's why I put this in here. Forget where it happened, maybe it was in New York, I think I saw it in the New York Post. Anyway, a teenager sneaks back into her parents' home in the middle of the night. She was out doing teenager stuff, and when she came back, the father thought that she was an intruder coming through a window. And after all, he thought his daughter was in her bedroom. There was no reason for anybody to be coming through a window, and he shot her. It obviously turned out that there was no threat whatsoever, but from the circumstances, it was reasonable because it appeared to be an intruder. The use of force is only allowed when the threat is either in progress or very close to being in progress. If someone says, I'm gonna fight you, and he starts rolling up his sleeves. Okay, that's good. You got to act. Uh, they say, when you grow up, don't throw the first punch. That is and isn't 100% true. A significant threat that's about to happen, you might be entitled to act. So, for instance, if someone that is, but again, this is all about balancing the circumstances. If someone twice your size starts rolling up his sleeves to punch you, perhaps you did need to kick him in the knee and run away. But if someone half your size is rolling up his sleeves, maybe you need to wait and see if he's actually going to throw that punch. Uh, and and again, that goes back to when we talk about level of force. If Hulk Hogan's at a bar and someone challenges him, I really don't think he needs to kill the guy. Defense of others, it's almost the same thing. It's really just a difference in uh, what we call the terminology here. It really is essentially the same thing. The reasonableness and the level of force has to be reasonable. The belief about the threat has to be reasonable, and the timing. The different one here is defense of property. It's similar, but the justification is less weighty when you're talking about property. So I'm looking right now at my guitar next to me. It's a beautiful guitar. I love it. If someone came into my apartment and said they were going to break it in half, I would be entitled to defend it. Obviously, I threw in a wrench because I said came into my apartment, that defending the home. But let's forget about that for a second. Someone, wherever we are, someone decides they want to break my guitar in half. They want to take it by the neck and destroy it. I'm entitled to defend the guitar. I can stand in front of it, put my hand up, push the guy out of the way, what have you. I can't kill the guy. It's property. After all, it is just a guitar. But if someone said, I'm going to break a person in half, then I have a high justification. I might even be able to shoot or incapacitate that person. I mean he's going to kill somebody. And I said it several times already, defense of the home is considered sacred. Force is more justified than with the protection of some other type of property. Of course, this is common sense. I have a giant farm, and somebody is, they're an acre away from the house, and they're doing something. I mean, that's not the home. That is my property, but they're not. It's not really the home. We're talking about the actual structure, and that they've penetrated the boundaries. They're inside, and it is assumed to be a threat. So if you see that, it 99 times out of 100, the homeowner is justified. Next, necessity. This is based on emergency situation, that it's permissible to engage in conduct that would otherwise constitute an intentional tort. And there are two types of necessity: a public necessity and a private necessity. The distinction being who is being protected, for whose benefit is the tort being committed. Public necessity, it's to protect the community at large or a significant group of persons. Classic example, there is a forest fire and it's going to come into some town. We need to destroy a couple of houses on the boundary in order to create a fire break. So the fire, there's nothing for the fire to burn to make it into the town. You destroy and create an opening. And whoever lives I guess, don't live on the outskirts of town, because if your house gets destroyed, you are not entitled to damages. The person who does that is not liable for damages. The idea here being, we don't want to prevent people from doing things to save the community at large. You might say, I don't know if I should make this fire break because I'm going to be, one house could be at $300,000. You really want to pay that? Now, this is done that way. You can save the community without being liable. I mean, Spider-Man would be $1 million in debt to the city of New York if public necessity wasn't a doctrine in torts. Private necessity is the same thing, but you're saving yourself. The idea here being, well, if it's just you and you really need to do it, fine, do it, but you have to pay damages. Now, you might ask yourself, well, what's the point of having a private necessity as a doctrine if you have to pay damages. Isn't it the same thing? Sorta, yeah. But the difference here is that the doctrine is pretty broad. That the owner of the property is no longer entitled to exclude you from the property. So this is both a torts and a property doctrine. But the effect of this of private necessity is really a property thing, because, and you'll see the example on the next page, but I'll discuss it here. If there's a storm and you drive a boat, you can't go back out to sea. You say, well, I'm going to pick that dock there. I don't know who owns that, but I'm going to dock up there and ride out the storm by mooring up in this dock. Because if I go out to sea, I'm going to die. You have to pay for any repairs to the damages your boat caused by banging into the dock during the storm, and you have to pay a rental fee. Okay, those are damages. But what's more important, and this is the true effect of private necessity and where it comes into play in property, is the idea that the owner of that dock cannot exclude you. Normally, owners of property have the exclusive right to exclude people. If someone comes onto my land, I can exclude them either by getting an injunction or calling the cops. Gone. But in this situation, the property owner does not have that right when there is a private necessity. The would-be victim essentially has a tiny little property right in his bundle of sticks when there's an emergency to stay in someone else's land. And here we go. Classic examples of necessity and docking a ship in a private harbor. That's what we said. You have to essentially pay the rental fee and any damages. Another example, driving a car off the road and onto someone's property to avoid an accident. This is a private necessity in which defendant pays for any damages to the property. I think this one was either on my bar exam or in a bar exam practice that I had taken someplace, so that's why I thought of it. And it's kind of weird because, you're going to have to pay damages anyway. Who cares if you call it a private necessity or not? And unlike the boat one, there's not even a chance that the homeowner can exclude you. It's not like you're in midair driving your car and they call the cops and they prevent you from driving off the road. But in the question that I was on the exam, you were asked what doctrine applies. So there it is. The lesson learned here is that the MBE, they're not always the best examples or the most real-world type examples. They just apply the law and don't really think about the practicality of it. Of course, I've said it already. Make sure to distinguish between private and public necessity, since it affects whether or not the defendant is liable for damages. The defendant's always going to pretend or argue that it's public necessity in order to avoid liability, and the plaintiff is always going to argue that something was private necessity. So that's the battle that there's going to be whenever you see a necessity type argument. The defendant's going to say, "Oh, well, there's 20 of us. That we're the public, aren't we? We're the community." And the plaintiff is going to say, "Oh, you're just 20 people. That's private. That's yourselves." Those questions are hard. There's no right answer. I don't think that will be as much of an MBE thing as it would be an area for discussion when you're doing an essay. So I wouldn't stress at where the line is drawn between public and private. I think it'll be pretty obvious on the exam. But I guess a rule of thumb is that public is sort of a group that you can't really put your thumb on. A fire break to prevent a town from burning, maybe who is it really? It's not like you can make a list of the names. It's just the public. It's just community. It's people. Whereas private is an identifiable core small group of people. And then a bar exam alert here, a point is to make sure to determine if the defendant went beyond the scope of justifiable conduct. So we said that a defendant that has a boat during a storm is entitled to dock up and ride out the storm. That the homeowner or the property owner cannot exclude him. True. Maybe he stays in the boat. Maybe he gets off on shore and hangs out. I don't know. I don't drive boats. I don't know exactly where you would go or what you'd call it. But I do know that he can't break into the dock master's house and sleep in his bed. That goes beyond the scope of justifiable conduct. And next, we're going to turn to part 2, which is negligence, and section A, which is the duty question.